My name is Jim Condos. I'm the Secretary of State, and with me is Brian Levin, my Deputy Secretary. We're here to talk about Vermont transparency and how it affects government. We're going to talk specifically about open meetings and access to public records. But just to give you a little background on who I am, I served 18 years on the South Burlington City Council. The last 8 of those years, I was the chair of the council. I served 8 years in the state senate. I chaired 2 committees, both education and government operations. Government operations is actually the committee that oversees the Secretary of State's office. So I've got a pretty good handle on a lot of the legislation over the last 10 years or so that have come through there. Brian, I'll let Brian talk about his background.
Yeah. Sure. For the 12 years before I started working with Jim, I was at the Legislative Council and drafting in the areas of government operations. So one of the areas we dealt with actually fairly regularly was open meetings and public records. So I've had an opportunity to see these debates come up fairly consistently, and have an appreciation, I think, for how complex these parts of the law can be. So hopefully we'll get some good discussions going.
Thanks, Brian. Also with us from up the Montpelier way is Alan Gilbert from the Vermont ACLU and Steve Jeffrey from the Vermont League of Cities and Towns. They were both part of the, if you want to call it, the partners or supporters of doing a tour like this. And this is, tonight is the 6th out of 12, so we're halfway through. We've got a bunch on the other side of the state to do from south to north. So we'll be, we're still moving along, and it's been enjoyable so far, and we've been getting a lot of good comments, and I think there's been a lot of good discussion. You'll have to excuse me. I'm coming off of the flu this past weekend. Literally, I was in bed all weekend, and so I've been trying to fight that, and between my prescriptions and cough drops, water, you name it, I've got it. So, but anyway, if I start to cough, I'll be okay. I'll just turn around for a minute. What brought this on? What brought us here? Why are we taking this tour around the state? And I think what it comes down to, very simply, is that as someone who actually came up through the ranks through local government, I realized very quickly, from the standpoint of listening to the testimony in the legislature, that there's a difference between the state government and local government, but on the same point, we're also very similar. And the issues of access to open records and open meetings, the issues are the same, but the responsibilities are somewhat different. And I think that what we're trying to do is just create an atmosphere where people understand the laws a little bit better. At the local government, I think what I believe and what we find is that most people are lay people, they're average people, they're working people, and they're just trying to do the best they can for their communities. So I think it's important that we know, going forward, what is it that we have to do? And there's been a lot of misconceptions. We get calls every day of the week, emails about how the process of government works, and people wanting to know. We get them from the public, we get them from select board members, we get it from auditors, town auditors, we get it from everybody, the clerks, treasurers. We'll get calls or emails from everybody all week long. And I think it's just really important that we work together. I know Steve has a crew, like a call center at his office, the Municipal Assistance Center, that does the same thing, answering calls to communities. And I think that what we're trying to do is just get the message out and go through the laws. So we'll get started. We're going to talk about, first thing we're going to talk about tonight is open meetings, and the second half we'll be talking about public records. And if you don't mind, I'm going to sit down because it'll be easier for me if I'm down here. So why are we here? We're here because it's about democracy, about accountability, about openness, and it's about the public's right to know, and that comes from the Vermont Constitution. Vermont's open meeting and public records laws are some of our most important because they allow us direct access to the decisions that actually affect us. And a full understanding of these laws makes everyone a better citizen. where do we get our power from? Where does the power actually reside? In government, the ultimate boss is the public. And I think it's a pretty simple statement, but I think if you look at what Vermont Constitution, Chapter 1, Article 6 says, that all power being originally inherent in and consequently derived from the people, therefore all officers of government, whether legislative or executive, are their trustees and servants, and at all times, in a legal way, accountable to them. And I think that says it pretty simply. And you'll see this come up as we talk about both open meetings and public records. In the declarations of public policy, this first one, subsection 311, is actually from the open meeting law. And it says basically that public commissions, boards, and councils and other public agencies in this state exist to aid in the conduct of the people's business and are accountable to them pursuant to Chapter 1, Article 6 of the Constitution. And this one here is actually subsection 315, is actually from excuse me, the public records section. And it says that the policy of this subchapter is to provide free and open examination of records consistent with Chapter 1, Article 6 of the Constitution. Officers of government are trustees and servants of the people, and it is in the public's interest to enable any person to review and criticize those decisions, even though such examination may cause inconvenience or embarrassment. And by the way, if you have any questions, feel free to stop me right as we're making the presentation, because I think what I'd like to just say is I don't believe in just making a presentation and holding all questions to the end. Let's talk about the questions as we have them. So what is a meeting? A meeting means a gathering of a quorum of the members of the public body for the purpose of discussing the business of the public body or for the purpose of taking any action. What is a quorum? A majority of that board. What is discussing board business or taking action? Pretty simple. If you're talking about board business, anything to do with whatever you're responsible for, then it is about board business, and you need to be careful, especially if the board is meeting in a social function or social activity. If you're at a football game, at the coffee shop, and a quorum gets together, you need to be careful about not talking about the business of the board, so that you're not accused of violating the open meeting law. There's also a specific mention in the school board language that specifically says that school boards must follow the open meeting law. Although I think we all knew that in the beginning, there is that specific mention in the Chapter 16, which is the school section. So what is a public body? Under subsection 310, a public body means any board, council, or commission of the state, or one or more of its political subdivisions, any board, council, or commission of any agency, authority, or instrumentality of the state, or one of it or more of its political subdivisions, or any committee of any of the foregoing boards, councils, commissions, except that the public body does not include councils or small similar groups established by the governor for the purpose of advising them. Yes, sir.
Just an odd question came up at one point. If a majority of the board were present, say at this meeting.
We've had that happen already.
Okay, so, and we're talking about things that are related in some way to can that constitute a legal meeting if it's not been warned to the public?
If you're got a 5-member board and 3 of you are together, right, and you're actually talking about it amongst yourselves.
Well, what if we're talking in the meeting?
If you're talking in the meeting, I would not classify that as violating the open meeting law.
Okay. It's only if we're kind of talking amongst ourselves.
If you're talking so that you're talking as a group, and you're talking about business of the board, right, then you would be dealing with a meeting situation. Do you agree, Steve?
Yeah, and I would agree that it's not, as long as what you're talking about is the state law about public.
I'll take it one step further and then I'll shut up. But suppose I would say, well, let's say we're 5 members, but there are 2 of us here now, so we're okay. But I said, when we talk about that, so when you said that really wasn't really appropriate, or would that be, could I cross the line if I'm not careful?
Yes.
No.
Yes.
You could. if you start talking about board business.
Okay, fair enough.
So you're not going to do that, are you?
Yeah, that's where I was headed. No, there's not a majority here, I can say anything else.
We actually had 4 of a 5-member select board show up at one of our meetings. 4 members of the 5.
Yeah, I mean, so if they got engaged in an argument about the open meeting law, you could, anyway, enough said.
There-
Enough said. We could get to it.
So who does the open meeting law not apply to? It doesn't apply to the judicial branch of government. And if you go back to the original piece from the Vermont Constitution, you'll notice in there it said the executive branch and the legislative branch, and deliberately left the judiciary out because the judiciary has its own set of rules. It also is the Public Service Board, which regulates the utilities, the regulated utilities. Any public body in a connection with a quasi-judicial proceeding, Development Review Board, site inspections for the purpose of assessing damage or making tax assessments or abatements, obviously BCAs, clerical work or work assignments of staff or other personnel, and then routine day-to-day administrative matters that do not require action by the public body. So if it's just regular routine work that the administrative staff does, but doesn't need the action or the oversight of the public body, that would be provided in this area as well, provided that no money is appropriated, expended, or encumbered.
Jim,
Yes.
would you go back up to the quasi-judicial proceeding? You
Yep.
used the Development Review Board as an example. Are you saying they do not have to abide by the open meeting laws?
When they're acting as a quasi-judicial board, they do not.
And only during their deliberations.
Just during,
Right.
okay, all right. fine.
When they're acting as a quasi-judicial board at that point in
Just
time.
during deliberations, but the rest of their meetings have to be.
Yes.
Oh, okay.
I'm sorry, I didn't mean to.
Yeah.
Okay, meetings and notice. There's 3 types of meetings. There's regular meetings, special meetings, and emergency meetings. A public body, a regular meeting would be when, right after the election, you have your reorganization meeting, and you set your select board meeting dates as the 1st and 3rd Mondays at 6 o'clock at City Hall. That's a resolution you pass at the very beginning, and that's your notice. However, you do have to, whoops, I get itchy with this finger here. You do have to provide an agenda on request as your meetings are coming up. So if you've got a meeting coming up, you do, and someone asks you for an agenda, you do have to provide it on request. A special meeting is the time and the place and the purpose of the special meeting must be publicly announced at least 24 hours in advance and requires a minimum of 3 public postings, including the clerk's office, and to each member of the public body. I'm sorry. If the news media has also provided a written request for notification of meetings, then they must also be notified. And we'll get into this a little bit later, but what happens with media, there's a provision in the law that says for the media that they can provide a written request, and it's good for a calendar year, so that anytime there's a special meeting, that they should be notified of a special meeting. So they have to provide that written request in order for that to happen. It's good for a calendar year. If the media gives that letter, provides that letter to the select board or the town, say in November or December, then it carries over for the additional calendar year. So it's not just the last 2 months. Am I moving around?
You are.
They told me I was dangerous with this thing. There we go. There's too many buttons on here, that's the problem. Emergency meetings, these are meetings that are called, where a select board is called to respond to an unforeseen circumstance, an act of God, flooding, Hurricane Irene, a fire, whatever, and you can actually meet without notice, but you should try to provide notice if you can, but you can meet without notice as long as everybody is notified that you are having that meeting. Did I see a hand up? No?
The very last phrase seems odd, because if you don't have anything up, you've got to give it as soon as possible before we actually meet.
If you can. In other words, let's say tonight you decide we need to meet tomorrow morning at 10 o'clock. The earliest possible notice time might be 9 o'clock in the morning to provide a notice, to set it up, to put it at the, sorry.
This is a true heavy-handedness.
I think we're done.
Maybe I'll just put it down and just use the computer. Yeah, I mean, I think you should try to provide notice, but there is an exemption there for you not to. Yes, sir.
Did you provide any specific guidance to towns during the state of emergency about how, or is there specific guidance you might provide as far as like when a state of emergency is imposed, like in the wake of Irene? And I know a number of select boards are meeting almost every day. Did you offer any guidance that might be shared or any good?
I think there was a lot of guidance going out there, I think probably from Steve's office, from my office, if people contacted us. We would relay to them what the law says. When you get around to the emergency meeting and special meeting, I think if all of a sudden you meet the first time because of the emergency, and that is an emergency meeting, but if you decide at that meeting, okay, we're going to meet every day at 10 o'clock in the morning,
Then it becomes a regular.
then it becomes a special meeting.
Oh, okay.
So you should notify. What?
Well, if you actually adopt a resolution to meet on a regular basis, then it's a regular meeting.
Okay.
So you could take it either way then.
Okay.
And opportunity to be heard. The public has a right to a reasonable opportunity to express its opinion on matters considered by the public body during the meeting as long as order is maintained. And public comment shall be subject to reasonable rules established by the chairperson. So essentially, I mean, I don't know about, what some of the issues might be down here, but when I was chair of the select board in South Burlington and the city council, we had a $10 million general fund budget. We might have 3 people show up for a public hearing on a $10 million budget. But if we had a discussion coming up about leash laws, dog leash laws, we'd have 150 people show up. 75 would be for it, 75 would be against it, and they all wanted to tell us. And you have to give people an opportunity to speak. And it's easy to say, look, we don't want to hear the same thing over and over again. Everybody has the right to speak. What you can do as a chair, and what I did in that particular instance, was tell people, we're going to limit you to 2 or 3 minutes. So try to keep it as short as you can, get right to your point, and we'll let you know when your time's up, so we could keep the conversation moving. It becomes, I know a lot of select boards say, yeah, but I might be there until midnight. So what? That's the burden that you have as a elected official, is to hear the public. School boards also have to follow this. They have to provide reasonable opportunity as well. It's kind of interesting that there's this redundancy between both the school boards and the rest of the public bodies. Minutes. We probably get, every week we get comments about, or questions about minutes. Essentially, the minutes shall cover all topics and motions that arise at the meeting and should give a true indication of the business of that meeting. And this section right here is basically the minimum requirements of what is required in a set of minutes. You need to list all members of the public body that were present, all other active participants in the meeting, staff people, whatever, all motions, proposals, and resolutions made, offered, and considered, and what was the disposition, and the results of any votes with a record of the individual vote for each member if a roll call is taken. And I think it's really important to remember that your minutes of your board meetings are really the history of your town. That's the history of your board. And it's important that the minutes be clear. It's important that they cover all the topics that you covered in your meeting. And that they're available, in law, they're available for inspection by any person within 5 days of the meeting actually having occurred. So even though it's not approved minutes, you have to have, you're required by law to have your minutes drafted by within 5 days after the date of the meeting, and they're available to the public if they want to look at them, or the media.
And what happens if they're not?
Well, there's nothing there's nothing to stop you from not having them ready,
No,
but
I'm
the
just
public,
saying if they-
the public has the right.
If the public came in and wanted the minutes and they're not there, what are consequences for a board?
The public could go public. Steve?
Well, I mean, also, there is a penalty under the law, which a person that knowingly intentionally violates the provisions of the subchapter
Oh,
is
okay.
subject to a misdemeanor and guilty and fined not more than $500. So it could, you know, I would assume it would take a pretty high threshold for a court to fine you in violation of that, but it could be a $500 fine.
For the person who is the recorder or for the?
It would be,
select
it's
board?
actually the body that's responsible for producing the minutes, so then they would be the ones that would be subject to the fine. A person who is a member of the public body.
Yes, ma'am.
As somebody who takes minutes of many school meetings in the district and the select board and some of the other boards of the town, it has been my understanding that if they're not in final form within 5 days, as long as you produce a copy of your draft in its present form, because it doesn't actually become official until that body approves them at their next meeting, that you've complied with the law. So if I've really gotten up against a time frame of this 5 days and somebody wants to see the language in that motion, I make them a photocopy of my notes and say, this isn't what it's going to look like, but I've complied with
This
it.
is what it is so far.
Yeah.
And I think you're making an honest effort to meet the statute, and I think that's really what the statute is asking, that you try to adhere to that. Senator White, thank you for joining us. Alan.
One of the things about your question, the penalty provision has been used, as far as we can tell, I think a total of 3 times since this law was passed in 1976. It's not generally used against public officials. One of the times it was used against either a city council member or the mayor of Montpelier, and he was convicted, but he was pardoned by the governor, Governor Salmon. So that sort of made people think that this law really doesn't have any teeth. And I think that's actually a problem. There ought to be another way to get people to abide by the language in the statutes. And that's why I thought the idea that the Senate worked on this year, there's a bill in open meetings that passed the Senate but not the House. They had the idea of somebody being able to cure a violation of the open meeting law. And that would be if somebody comes to you and says, where are the minutes? It's been 6 days. And you say they're not ready. Instead of that person being able to run down to the state's attorney and say, I want this person charged with violating the law, you would be given a chance to cure the violation by producing the minutes quickly. And, you know, that seemed to me to make more sense, actually, than putting somebody who probably is doing this as a citizen volunteer in danger of being fined $500. I mean, I take minutes, too. I'm on a school board. And, you know, it's sometimes hard when your kid is sick and, you know, you're worried about lice in the school, and that's what the minutes are all about. And, you know, it's just all these things. And I think most people try to do the right thing. Sometimes they're just not able to do it. They need a bit of a nudge.
I want to give you a real-life example here about how minutes are very critical to the history, but also how it impacts people's lives. In South Burlington, and I'm going to use my town as an example, and an issue that came up that frankly involved me as well as chair of the council. We had a city manager who retired I got off the board in 2007. He retired in 2009, 9 or 10, I guess maybe. He had been there for 20 some odd years. I had been on the council for 18 years. And I guess there came a time where the new city manager and the new city council, totally new council, were going through their budgets and going through their minutes, and they found that there was no place that the minutes showed that we had taken an action to on his pension or on another health care benefit that we had provided him. So they were challenging it, whether it was whether those were legitimate issues. And actually, 2 months ago, myself and three other counselors who were on the council at the time, we came to a council meeting and explained after a year-long, they hadn't asked us at all during that time period, but after a year-long discussion, public discussion about whether the city manager was entitled to these benefits, we came forward and said, look, we were the ones that were on the council at the time. We went into executive session. We negotiated these entitlements to them, these benefits. We came out of executive session. We voted them in. Why they're not in the minutes, we don't know. But we know that we took the action. And essentially, eventually he got his pension restored at that point. But it really has impacts, or can have impacts. That pension discussion was 20 years ago. The health care discussion that we had for him was 8 years ago. So you really need to have those minutes be accurate and reflect all the motions that were taken. Now, not to say that we should have done a better job and the manager should have done a better job. Typically what would happen in our city council is we would have a meeting going on. We might go till 10:30, 11 o'clock at night. We'd be going into executive session, and we would send our recording secretary home because we didn't know how long we were going to be. So the recording secretary would go home. We'd go into executive session, a properly made motion and all that. And when we came out, it might be midnight, and the manager at that point would be the one responsible for taking any notes for any action that we took at the end of in the open session. And typically he would write it on the back of a piece of paper, and when the minutes got to him 5 or 6 days later, he would add any motions to the minutes, and we might a month later get those minutes to approve them. In hindsight, we lost it. He lost the piece of paper. He forgot to put it in the minutes. We didn't see it for a month. We had 2 more sets of minutes in the meantime and just forgot about it. So there are real life implications. And, I think my dad always said to me when you make a mistake, own up to it, learn from it, and move on. And I think that I'm just trying to say that here's a real life example. What rights do the media have? First thing I want to say is the media is the public. They are considered the public. But upon request, the agendas of regular or special meetings must be made available to the news media prior to a meeting. And then we talk about here again, the news agencies that wish to be notified of special meetings must provide a written request to the public body. Members of the news media and the public have a right to attend meetings and to tape or videotape those meetings, so long as it is done in a manner that is not disruptive to the meeting. And the media and the public have a right to know the reason that a board is going into executive session. Mind taking over for a minute? The top one is the top one is the red dot. This is the one that moves forward.
All right, I'm going to pretend I'm Jim here.
I'm sorry.
Have you done it?
We did this one.
We're going to talk about the reasons when a board can meet in private. In general,
Just hold that down.
boards are not entitled to meet in private unless it's to consider any number of grounds for going into executive session. I got to find something to read on here.
While you're finding that, can I ask you a question?
Sure.
If you talk, and I apologize for coming late, I was at a radiological emergency response meeting, budgeting meeting, and I have to go after a little while to permit reform meeting. I don't know why all these state agencies have their meeting on the same night, but so anyway, did you talk about what do you mean by media here now that everybody blogs and thinks they're a...
We haven't gotten to that
Okay,
yet.
okay.
In this contest, we're talking about newspapers, radio stations,
Okay,
TV
yeah,
stations,
okay.
and those entities that want access to the information. To go into executive session, you need a motion that's made in an open meeting, and it has to indicate the reason for going into the executive session. We're going to get into those specific grounds for executive session after this, but the public body can invite into the executive session its attorney, or really anybody that it thinks it might be helpful to informing the public body. You can't make any decision in executive session, but what do you have here? Once you come out of executive session, then you make a motion and you take your formal action in an open session. You may make decisions in a deliberative session. This would be in the case of a quasi-judicial body, but you do need to produce a written record that is a public record. Here we have sort of the most common reasons that a local public body would use for going into executive session, and I really think the first one is really anything involving contracts, labor negotiations, litigation, and the standard here is really important. Just do this on a limited here, where premature general knowledge would clearly place the state or the public body or any other person involved at a substantial disadvantage. The second one is for negotiating or securing real estate purchase options, and this is really the only grounds or the only thing that you're considering that you can actually make a decision and take an action in an executive session is if you're considering real estate purchase options. All the other ones you have to come out of executive session to take the formal action.
Now, I guess we have assumed that securing an easement it's not quite the same as a purchase. Sometimes the town needs to acquire an easement from is that qualified or not?
I've never had. I mean, I've always thought an easement is a property interest, but it's not necessarily a real estate.
That's what I'm
purchase.
asking.
I don't know. Have you ever had this one, Steve?
No, but
It's a good question.
We've had it's happened several times that easement requests come through we need an easement in order to, even in this current situation, we've needed easements.
Yeah.
Like for a temporary bridge.
So you would say concretely, you need a temporary bridge, it's the middle of the...
I mean, the purpose is to make sure that on Tuesday night that the board doesn't do in an open meeting. I move that we offer Jane Doe $200,000 for her house and have somebody buy the place for $190,000 or $200,000, then offer it. It's just not to make sure that the town is put at a disadvantage in trying to secure real estate. I don't know whether
so it sounds like it's not a very. I mean, if you guys are saying it's not clear, then because to me, if we're a town and we're purchasing something versus we're a town and as someone says, I need so much money to allow the town to do such and such, then that we're negotiating about money and this normally, when you do such things, you talk to each other. They're kind of two sides of this. So I don't know. I guess you could call it quasi-judicial.
Or that may be getting into the area where you're considering a contract here.
You are considering it is a contract.
So
it is a
maybe
contract.
the first number one is
it's not a contract like a legal employment contract. But it just seems like it should broadly fall in this, but it doesn't seem like it exactly falls.
I think we'd have to do some more research to see whether it does or not. And what I hear right now is nobody here is actually willing to make that
Right, that's what I'm hearing.
without actually looking at the
Right.
statute.
So, okay.
Yeah, and we'll get into this a little more as we go along, but when the area is really gray and all other things being equal, a court is going to err on the side of openness or disclosure. So, I mean, you sort of have to factor that into the analysis as well.
I think the best thing is to actually contact your town attorney and just say, is this or is this not an executive session item?
But,
Look to them for advice.
Yeah, we don't, in those small towns,
Right.
you guys are our experts, I mean, honestly.
But again, I think from a practice perspective, if it's not going to put you at any disadvantage, why do you need to go into executive session?
I don't know, but if you were buying a car, wouldn't you want to talk with your wife without talking in front of the guy who's selling you the car?
Well, that's the whole purpose. You're right, but that would be putting you at a disadvantage one way or the other.
Oh, so that, you could argue that, okay,
Right.
all right, okay, I'll go with that.
But if it's an easement for temporary bridge and it's not a controversial thing, and
Well,
it's
it's
not
how
gonna
much
put you-
money, it's money, you're
Yeah.
saying, am I
Well,
gonna pay
that's-
$10,000, I'm gonna pay $5,000?
Yeah, I mean, I think that at that point, it does put you at a disadvantage.
all right,
and probably
all right,
would be a
I'll
good
go with
reason
that
to go
reason.
into it. So,
Okay.
I'm not a lawyer. But I will take
We'll
your
quote
legal
you,
bills
yeah.
if you're-
you plays one at this meeting.
Yes.
The third one here is if the board wants to consider the appointment or employment or evaluation of a public officer or employee. Number 4, for considering disciplinary or dismissal actions against public officers or employees. This does go on further, say if there are formal charges brought, that public officer or employee can demand to have the hearing in public. That's a right that employee has.
Who takes a disciplinary action against an elected official? Isn't that what public officer is?
No, that
No,
could
it's
be,
Police officer,
Okay, but not an elected, is that,
that's right.
yeah.
Unless there's something built into a municipal charter that would allow for that. That's right. And the fifth one being a clear and imminent peril to the public safety. These next may not necessarily involve local public bodies, except for perhaps number 7, academic records of suspension or discipline of students, and also if you're considering anything that's exempt under the public records law. Under number 6, you can go into executive session. So just to be aware of these other ones in case you find yourselves on a state board. Now,
I've seen this abuse, that I'm aware of a board, I went to another board's meeting at one case about it, and I noticed they kept everything that seemed to require a decision, they said they would discuss it in an executive session.
well, and it's one of the reasons why I think we're going on this tour.
Yeah,
Is
good. I mean, it's just a fact.
when I first served on solid waste districts, which they were formed around 1988, and I started to serve on representing my town in 1990. When I first got on the board, they used to go into executive session for anything and everything. And typically, at the solid waste district meetings, there'd be no public there anyway. So in a way, it didn't matter, but still, they were going into executive session for anything. And I remember that there was myself on one side, and then there was Marty Myers, who later went on to be a representative in the State House from the town of Essex, who was on the other side, but we both agreed on the process, and we both fought and said, you can't go into executive session for that. And it got to the point where we argued so much that they used to give us the motion prepared. If we were going to go into executive session, here's the motion you have to read into the record. So it can work to your advantage just to speak up a lot of times. And really, that's what the public is there for. That's what the media is there for. That's why they're considered part of the public.
Here, we just wanted to point out that if you don't follow the open meeting laws, then the actions of the public body may be illegal, and the consequences can be that the courts can void that action. They're not necessarily void just because they happen, but if they're challenged in one remedy a court could find is that they're going to void that action, which could force the board to have to do it all over again. Or, illegal meetings offend our notion of openness and accountability, and therefore our democracy. And I'm going to give the mic here back to Jim. I know his voice is hurting, but the boldface, I think the secretary should.
I think this just goes back to the Constitution. In Vermont, the people rule, sometimes directly, sometimes through their elected or appointed representatives, but always, and I say always, with the benefit of public scrutiny. And the Constitution, we go back to our Chapter 1, Article 6 frequently because that's the piece, that's the one article that you see throughout both public records and open meetings. That is the basis of both of those laws. And I do want to say that this year the legislature did pass the most significant upgrade to the public records law since 1976 when it was first enacted. And it was enacted as a result, basically, of Watergate. And a lot of states around the country were enacting open meeting laws at that time. Senator White, as chair of the Government Operations Committee, was intimately involved in both this and the open meeting laws, which there is a bill that has passed the Senate that Senator White took through her committee and through the Senate floor that is now sitting in the House, and the House will take it up in January. They did not have enough time this year to do both of these laws together, so the Senate did. The Senate always got their work done.
Thank you. He used to be in the Senate.
I used to be her chair. So, anyway.
We throw out a few questions here, and you know, the first one actually is the one Senator White raised already about what if a select board wants to meet online, and I don't know if any of you have any experience with this at all, or have you?
That came up at your select board meeting, right? Your Facebook?
Oh, yes.
I know we actually, the first time we, in our office, encountered this question was some town down here. It was like a recreational committee set up to advise the town. Maybe I'm getting my facts all. And they were interested in meeting in a chat room, I think. You know, the law does say that you can meet by audio conference or other electronic means as long as you satisfy the requirements of the open meeting law. So essentially you need to be able to provide that openness and access to your meeting that you would if you had it, you know, the traditional way, which, you know, I think you can manage by doing by audio conference, but to have it online in a chat room when there may be people out there that don't necessarily have access to a computer or even the knowledge of how to use that, there's certainly some concerns there that that's not open and that's not the accessibility that the open meeting law anticipates.
That's basically what
Yeah. Okay. Another question: if select board or school board adjourns its meeting and a quorum sits around talking, the issues come up. Is this still a meeting, even though it's adjourned? I know we had this question come up.
In the Northeast Kingdom.
This very thing happened, and you know, you boys feeling well enough to tell the story, Jim?
I got a call from a reporter who said that they had a community that they were reporting on, and at the end of the meeting, they were still, the quorum of the board was still there. They were talking about the budget. They were talking with the treasurer who was sitting in the audience, and all of a sudden the select board chair realized that the member of the media was still in the room, and said, well, let's stop here, and some of these questions might be embarrassing, so let's just meet with the treasurer separately and discuss our issues with the budget. and then we'll get back together later. And the media was asking, is that a violation? And I said, well, once they said they were going to meet separately with the treasurer, that was actually a good thing, that they were going to meet separately, because that's not a violation of the open meeting law. But I said, really what they were doing was violating the spirit of the law by trying to keep this out of the public view. After the report in the paper, the next morning, I get a call from the select board chair that I didn't understand what was going on. And I said, well, tell me. And he said, we were adjourned. We had adjourned our meeting. I said, okay, let me ask you 2 questions. Was there a quorum of your board? The answer was yes. I said, were you talking town business? Yes. And I said, then that was you were in an unwarned public meeting at that point, open meeting at that point. And he said, but you don't understand, we were adjourned. I said, doesn't matter. You had a quorum of your board and you were talking town business. Therefore, you are in a meeting. The next one pertains, do you have a supervisory union down here? About 2 years, not this last session, but the session before, the legislature actually set in place what's called a negotiating council to allow supervisory unions to have their individual school board members, school boards, assign a member representing them on a negotiating council to meet with the teachers over their contracts. And the question came up, again, it was from the media asking, can they meet in private? Well, that's kind of a loaded question, so I said, well, give me some more information. Well, we don't know where they're meeting, when they're meeting. All we know is that they are meeting someplace. And I said, well, they do have to follow the open meeting law from the standpoint it is a public body. So they have to follow the public meeting law. They have to notice that they're having a meeting, where, time and place. But they can have a motion then to go into executive session to go into their labor negotiations. So it really was 2 different issues that the media was asking at that point. But it was clearly, the point was, is a negotiating council, the question to us was, is a negotiating council a public body? And the answer is yes. And limiting public discussion, we get this all the time. Can't we limit the public discussion? Technically, no. You can control it, constrain it a little bit, but you really can't limit it from the standpoint of saying, no, you can't comment on something. I know that select boards do it in different ways, but some boards will have a line item at the very beginning that says, an agenda item that says, public comment for anything not on the agenda. And then so public can comment on anything they want up to that point. After that, they can only comment on the agenda item that the select board is involved with at that time. So it's the area where you can limit is if you've got 100 people that want to speak, you can start to limit. You can't give everybody 30 minutes to speak because you're not going to have, you'll go for days. But you can limit it to 2 or 3 minutes at that point. I'll try it for a while. So that's the open meeting section, and that we expect that law will see some changes this legislative session. As I said, Senator White's committee put theirs through, and now it's waiting for the House to take action on it. So what is a public record? It's any written or recorded information, regardless of physical form or characteristics, which is produced or acquired in the course of public agency business. And putting it simply, all government records are public records. Some public records have exemptions, but they're still considered public records, but they have exemptions to keep them from the public's eye. And keep in mind that public records are not just limited to paper. They can be CDs, DVDs, computers, your hard drives, whatever it is, whatever way you're collecting that information in the course of doing the agency business or the municipality's business, that's considered a public record. Yes.
We had a question come up last night at the abatement meeting. As far as the records that the individual members of the board have, are we to retain them? or if it would recycle them, or in the form of paper. It was unclear as to what we're supposed to do with those.
It's, you go back to the definition, it's those that are acquired by the public body. Doesn't say individual members, but I think if they're used by individual members and as part of their decision-making process, then they most likely would be public records.
Well, I think what Mary is talking about is
Each member's,
because what each member receives is recorded in the actual record and in the town record, but those are copies of the same. So,
I mean, I guess the point I would make is that I always abided, the way I looked at it was everything that, as a city councilor, everything that I had, the city manager had a master file on it. And I'm assuming the same thing happens here. So that information, the public record is actually, is kept. And I don't think that the information that you per se have, unless it's something that was handed to you in a meeting, that the clerk's office doesn't have or somebody doesn't have for that public body, for the BCA or whatever. So if it's a specific piece of paper that was handed to one person, my advice is to turn that over to the clerk so it's recorded.
So again, we're just showing you the section that states the statement of policy and just gives us a chance to emphasize a couple parts of it. The policy is to provide for free and open examination of records consistent with the Vermont Constitution. Officers of government are trustees and servants of the people, and it is in the public interest to enable any person to review and criticize their decisions, even though such examination may cause inconvenience or embarrassment. All people do have the right to privacy in their personal and economic pursuits, which ought to be protected unless specific information is needed to review the action of a government officer. And then we have the declaration of policy, and at the end, and this involves a recent change as well, or a codification of case law that's now put in this section. The provisions of this subchapter shall be liberally construed to implement this policy, and the burden of proof shall be on the public agency to sustain its action. And there's case law that already sets this precedent of the burden of proof, but we actually have that codified now in this section of the statutes. When can the public inspect? For state agencies, it's 9 to 12 and 1 to 4, and it's during customary business hours for local public agencies. In general, the identity and motive of the requester cannot be considered when weighing access to public documents. I think we say, don't ask, but in general, the real point is that their motive for wanting the information should not go into your factoring whether or not they get it. If it's exempt from public inspection, then you can deny it on that basis, but not on the basis of their motive or what you assume their motive is for using that information.
and what is exempt from public inspection?
Well, we're going to get into that.
Here we go.
How about that?
Anticipatory question.
Yes, thank you. We need to bring you with us on all the tours.
Wouldn't you be?
Public agencies are required to produce records unless they're exempt. And in section 317, we have a list of exemptions. There's 40 of them in this list. Some of them which actually cross-reference other state and federal laws. And when all said and done, the number is upwards of about 240 exemptions, plus another 20 or so that our State Archives and Records Administration has identified as exemption-like language out there in statutes. So, we're really in the 260 type exemptions, but a lot of which, I shouldn't say a lot, but many of them kind of overlap with each other. I think there's about 10 different ones that deal with exemptions for trade secrets and currently, and I don't know if you want to take the opportunity, Senator, to explain your activities up at the State House, but the act that passed last year created a legislative study committee that's in the process of reviewing the exemptions that are out there, and
We're just going through them individually to find out if they should remain exempt or if they're not needed anymore. And I think that for many people, getting the number down from 240 to something less than 240 is important. For me, it's not important what the number is, but that everything that is listed as exempt truly is exempt. We might find that some are lumped together where they shouldn't be, and we end up splitting them apart into two exemptions rather than one. So the number to me isn't important. It is to some people. And then we're also looking at, and I don't know if you're going to touch on this at all, but if you don't, I would ask people later on to think about how, in terms of public records, how municipalities deal with the issue of separately elected. Are you going to deal with that in this section?
Separately elected clerk versus...
We're dealing with that issue also. First of all, the definition of privacy, and also the issue of, in a town, you'll have an elected town clerk, an elected treasurer, maybe separate elected listers, and elected select board members. They're all subject to the open meeting law, or public records law. So somebody requests a record from the lister, and the lister said, oh, no, I'm not going to give that to you. And the select board says, wait a minute, you got to give that to him. And the lister says, no, the select board is not the boss of the town clerk or the lister. So how do you deal with that? If there's a suit, it's the select board, it's the town that's going to pay. So we're trying to figure out from municipalities, how do we deal with that issue of public records where there isn't, in state agencies, there's somebody in charge of the state agency, and that person can call the shots and say, you better do it. It's different in municipalities. So we are dealing with that, and at some point, love to have this whole room come up and testify to us. But anyway, so that's what we're doing over we call them summer study committees, but obviously my car was covered with snow when I got here tonight, so it isn't just extending into the summer.
now here's some examples of some of the exemptions involve those for personal documents relating to an individual, investigations, trade secrets, tax records, and it's recommended that each agency, they maintain a compilation of the state and federal laws that they create these exemptions, so it's easier to process the requests as you get them. Yes?
So do the requests have to be made in writing? From
No.
the agency? No.
No.
It's exciting.
But it's coming up.
Oh.
Before we get to that, just so
You can go with us too around the state.
you just wait one more slide and then ask your question. No. Here again, we have a little explanation of the burden of proof, and this comes from a Supreme Court decision that the Public Records Act represents a strong policy favoring access to public documents and records. Exceptions to that general policy of disclosure are listed. We construe these exceptions strictly against the custodians of records and resolve any doubts in favor of disclosure, and the burden of showing that a record falls within an exception is on the agency seeking to avoid disclosure. We have on our office's webpage what we refer to as the Right to Know database. The link's here for you. It's a fairly useful tool for seeing the whole list of all the exemptions that are out there, and there are also links built into it so that you can see the legislative history to the extent there is some behind each of the exemptions, and then any case law that may have further interpreted these exemptions. All public agencies are required to comply with a request for a public record. Unless otherwise allowed by law, they must accept records requests in any manner or format, which means verbally. If somebody gives you a verbal request, and arguably it could be disputed whether or not that request was made, as an attorney, I would always advise somebody to put that request in writing, and then you have some proof of it. But the law does allow for verbal requests, and does require a prompt response to those, just as if they were in written form. An agency may require a request to be made in writing if there's staff time that's going to be involved that are going to contribute to the cost of complying with that request. And upon receiving the request, the custodian of the record must promptly produce it. If the record's in active use or in storage and not available at the time of the request, then the custodian has to certify in writing that the records aren't currently available, and then establish a day and a time within 1 week that the records will be available. And if it does not exist, that the custodian has to certify in writing that the record does not exist. If the custodian thinks the record's exempt, then it has to certify that in writing and explain the basis for the denial, which exemption applies. Unless there are unusual circumstances, and we'll get into that next, the certification must be made within 3 business days of receiving the request. The custodian also has to inform the requester that he or she has a right to appeal to the head of the agency. If it's appealed and the agency head determines that the custodian must comply with the request, then the records have to be made promptly available.
In that second bullet, that's exactly the point that Senator White was making, is because it says that you're supposed to have a right to appeal to the head of the agency, and who is the head of the agency in a municipality, and I think that's where it comes down to. That's what they're dealing with, trying to figure out how that's going to be answered. But you'll notice that anytime you're denying, you really have to deny in writing, and you have to explain why, which exemptions that you're using.
So here's how the statute defines what unusual circumstances are. The agency can't comply within the time limits that we just went through. If it needs an extension, it must submit a written notification to the requester and specify the reasons why it can't be made available then, and then the date when a determination will be made. Any extension can't exceed 10 business days, and they're only allowed if the need to search for and get the records from field facilities or other establishments that are separate from the main office, or the need to search for, collect, and appropriately examine a voluminous amount of records, or there's a need to consult with another agency that has a substantial interest in determining whether or not the request is exempt or not. If access is denied and it's appealed to the agency head has to make a written determination within 5 business days, and that determination shall include the statutory basis for denial and a brief statement of the reasons and supporting facts for the denial. If it upholds the denial of the head upholds the denial of a records request in whole or in part, the agency shall notify the person of their rights for judicial review. If it reverses the denial, then the records have to be promptly made available. Are there any questions? This is sort of just the nuts and bolts of the law, and now we're just going to run through the changes from this past year.
And the changes are available. There's a single page. I don't know if you picked it up, but there's a single page document up on the table in the back that actually lists all the different types. We're going to go through just a few of them.
This first one is to, I think, build in a little bit of flexibility to the process. When responding to a request to inspect or copy a record, the public agency is required to consult with the person in order to clarify the request or obtain additional information that can help the public agency in responding to the request. And when authorizing, facilitating the production of the requested record for inspection or copying. I mean, this just allows for a little bit more back and forth, and hopeful, in some cases it may allow the parties to refine the scope of the request and reduce the workload on the public agency, and maybe even help the requester focus in on the real information thereafter.
Do you have any examples of kind of what might be, first of all, denied, and then something like this of where it's just overpowering and you need to try to get them to narrow it?
I don't know, this doesn't really go to a denial, this goes to,
Yeah, I forgot to ask the question before you get off the other.
then I guess I'm not clear on what your
Well,
question.
why don't we just stay with this one then?
Okay.
You know, a topic that would need to be narrowed. And I heard somebody back here say, okay, you.
Somebody comes into the town clerk and says, I want to examine every single contract that you've had with anybody who doesn't have a Putney address in the last 25 years.
Do people come in and do
Yes.
things like that?
Yes.
Come to our office.
So what they might really want is to find out if a certain person has been getting a contract to pave a certain section of the road. But they don't know how to frame it. I mean, sometimes they're just asking because they're...
It could also be a
But-
huge database that the town has, voter checklist as an example, I think, and perhaps they're only looking for a specific piece of information, but they say, give me the entire database, and Annette has to say, well, that's going to take me a little while to put that together for you. Can you tell me what it is specifically you're looking for, and maybe we can get it quicker? And that's all that is. It's just designed to be flexible.
Yeah.
Question.
Oh, I'm sorry, Annette.
I'm not sure if it's a question or more of a comment. I guess maybe it's a question on how you deal with someone who does ask for unreasonable information and wants everything of this and everything of that, and just goes down the whole list and asks everyone in the state for the same information.
Oh, and they're out there.
Oh, we know that. We know.
Of course.
I mean, how do you deal with that?
They're called data miners, and it's a burden of being in the public domain. I mean, if it's a public information, you have to provide it. There's just, you can't get around that. I think the question comes in making sure that if he says, I want the entire database, it's up to you to make sure that everything in that database, before you give it to him, is not exempt. Is not exempt from law. So before you go turn over a CD of the entire database, you need to make sure that all the fields in that database are exempt, because there might be Social Security numbers. You obviously want to take those out. So
Are you in compliance if, for instance, someone says, I want a copy of every voter registration form you have in your office? It's public record, but it's not computerized. Are you required to copy every voter registration application, or can you say to them, I can make the records available to you, these are the hours we're open, and you're welcome to come in and peruse at your leisure? Can you say that to them?
you can.
Well, it
Well,
depends
you
on
could
what they
say-
request.
You
But
could
it
say
depends.
that, but if he says, no, I want to have every
If he wants a copy, then you have to provide a copy. But you also, at that point, can say to him, well, I think it's going to take X amount of time for me to make copies of all of these records. It exceeds, there's a couple of slides here, we're going to get into the fees part, but it exceeds the 30-minute limit, and everything thereafter you're going to have to pay for from staff time. Plus, we're going to also factor in the cost of the cost of printing those. And here's, in writing, you have to provide them an estimate of what the charges are going to be. And you can require that before you go and do that work, you get a check from him to pay for it. But we'll get into it a little more here.
Thank you.
Another change is really to put into statute what's always been a best practice, and I think at least there was testimony in the legislature that people were using the fact that there may be exempt information in a document as a reason to deny access or inspection of the entire document, and now the law specifically states that that's not reason enough, and that in fact what's required now is that that exempt information be redacted and the rest of the document be produced for inspection or copying.
I think an example might be where you have a document that might have a Social Security number in it. And so someone might say, it's got a piece of exempt information in it, therefore I'm not giving you that. Now the law says you have to redact the social security number and provide the document. And if it was a list of social security numbers, you could redact the whole document and give them the document redacted.
It's a new requirement that accommodations be made for disabilities requesters. This is probably what received the most attention in the law and is, I think, considered, well, I won't put any spin on it, but previously, if there was litigation involving a denial of a public records request, that the person appealing the denial to a court, it would be in the discretion of the court to award attorney's fees to a requester that prevailed in that litigation. And now what's changed here is that a judge is required to award attorney's fees and litigation costs to that requester that substantially prevails. There is an opportunity for the public agency to give up the documents. I think it's within 20 days of the commencement of the lawsuit. But in that case, the judge still has discretion to award attorney's fees and costs. But if it goes to trial and the decision's rendered and the requester substantially prevails, then attorney's fees are mandatory. You want to add anything to that, Jim?
I think this was really the key piece of the legislation, and there's a lot of folks I know, especially in the municipal community, that are concerned that this might be a huge new burden on them. If you're following the law, if you have good management of your public records, and you follow the law, it's not going to affect you. I think where this comes into play, when you look around the country, the states that have the strongest laws, and I think the legislature was not only convinced of this, but found this to be true, the states with the strongest laws on public records happen to be states that had mandatory attorney's fees. I came from local community, local government. I actually believe that this is not going to impact. It will impact some communities, I think, if they continue to have the attitude of no, you can't have that document, and then it's proven that they are required to provide that document. I think if you follow the law and you pay attention and you have good public records management, Greg Sanford, the state archivist, and I we've continually talked about good records management. And if you have good records management, then you're not going to have a problem in providing the documents that people are looking for.
Now, this isn't a new change, but as far as copying records, agencies with the equipment necessary for copying must use the equipment to produce copies. Agencies haven't been required to provide or arrange for the removal of a record for copying off-site. And no state agency is not required to create a new record. It can't be obligated to. If an agency does receive a request for a record that doesn't exist and is willing and able to develop it, it may charge for that undertaking, and before doing so, it should provide an estimate of the charges in writing and may require payment before it commences the effort. The fees for copying, you have to follow the standards that are established by law. Absent any particular fee, public agencies must establish fees based on what is currently allowed under the law. You may only charge and collect from the public the actual cost of providing the copy, which includes mailing or otherwise transmitting the record. You can't charge for staff time unless it exceeds 30 minutes. or you agree to create a new record, or you agree to provide the record in a non-standard format and the staff time exceeds 30 minutes.
Does that public record include, like, copies of tax bills? Somebody comes in and says, oh, I lost my tax bill, can I have another copy? So we can only charge like the 10 cents for the photocopy?
Right, I mean, you're assuming it doesn't take you more than 30 minutes.
We don't move real fast.
I think that's right.
I mean, I've heard things going back on our, forth on the meeting net in terms of charges for.
Well, there are specific under, particularly in the clerk's office, under Title 321671, I think, that has
Yeah, I've got-
a lot of specific ones that are set forth, and I would say those probably prevail over the 10 cents a copy when you have to.
Oh, yeah, I understand that,
yeah.
but if it's not out of my office and somebody else is charging, and it's not a document that meets like the dollar for a
Right.
kid or something,
Right.
then they shouldn't be charging more than the copy cost?
I would say so.
Yeah, that's what I would say.
Yeah. If requested, the agency has to provide an estimate of the charges, and the agency may request that any request subject to staff time charges be made in writing, and that all charges be paid prior to delivery. And keep receipts. The Secretary of State is charged with establishing the actual cost of providing public records that may be charged by state agencies, and also what can be charged for staff time. This is done through a uniform schedule of public record charges, which and the factors are actually set forth in statute. And I believe, as I've learned from doing the tour with Jim, that we're going to undertake some revisions to these charges.
It's been 7 or 8 years since these have been reviewed, and I could, like most people, I'm sure that you understand that the costs of copies and whatever have gone down, but the cost of the machines for them have gone up. So there's a lot of different factors that have to be factored in, that have to be looked at, and staff time has probably increased in cost over the last 7 to 8 years. So we're going to be working with the Secretary of the Administration and Buildings and General Services to determine what those costs are and come up with a uniform schedule. Municipalities are allowed to set their own, but if you don't, then you have to follow these. Yes?
So given that information, what is the turnaround time from the request that would be made? In other words, how long would it take for you to get an estimate to get the records that you wish?
You still have to meet the public records request timelines. If you say you're going to deny, you got to deny. You got to notify them within 3 days. If you say you need more time, you've got 10 days, but you have to provide a time certain.
What if someone can't afford to pay?
That's the law says that you can charge.
So you would deny their access to the record?
If you have to expend those costs, I mean, it's still under your custody. The record is still under your custody. I can't tell you what to do with it if they can't pay for it, but
Jim, I don't think the law says you have to charge. I think it says you may charge.
right.
So if you choose not to charge somebody,
If you decide it's okay and
That's true.
let it go,
I
and that's
would-
exactly where I was going to end up.
oh,
But if your select board has adopted a policy for using, for copies or whatever, then we are obligated to charge. Right? I mean, you just don't.
Right, so you have a policy.
I mean, I would think if somebody had and felt they were unable to pay for something, their request would have to be, they'd be asking for really reasonable things. It wouldn't be like.
Well, we had someone who is frequently asking for information from our office, And he was asking for very large amounts of information, and he actually required us to do. He wanted us to provide it in a certain format, and we said to him that under law we don't have to provide it, but we're willing to do it because we think it makes sense that we can provide it in that format. So now the question is, do we charge for that or not? And I think in the case where if it was a specific example where it was just going to be for this person, we would have charged him for the staff time to put that. If he wanted something, let's say it's in the NEMRIC database and he wants it only in an Excel format, putting aside whether it's a simple request, but if you had to spend staff time to load that database up, you could charge him for it. There was a piece of information that this person wanted from us, and we told him it was going to cost $149, and he wasn't happy about that. And we said, well, that's what it is. If you want it, let us know, and we'll provide the documents for you.
And also, I think another response to your question is examination of records is always free. You know, you can't charge for just inspecting. So for somebody that doesn't have money, that could be an option if they're not willing to pay for the copies. Any other questions? Yes, sir.
I have a question actually that goes back far back to the open meeting part. So one of the things that comes up a lot is email. And where it's just, you know, I've heard various things on this, but the basic sense seems to be, you know, that where one person sends an email out to the board, says such and such is an issue that's come up. That seems to be okay to say that we need to discuss this at our next meeting. But then somebody responds and says, not quite this bluntly, but says, that sucks, that person's an idiot. And if they I know that if they respond to the whole board that way, that should be a violation of the open meeting laws. The notion I have is that you can't be having a discussion on email any more than you could have a discussion after a meeting openly. But this line gets crossed between information sharing and the board discussing, and it gets crossed frequently. So that's my concern. How do you advise keeping that clear what the division is?
That's what we're dealing with right now. And I think that's what the legislature has struggled with regards to open meetings. That's why the open meeting law took a lot more time to get through from the Senate side and over to the House, because they're having that very discussion on how do we deal with electronics and electronic media. To put it bluntly, our state statutes have not kept up with our technology that we have available to us, and probably never will. It's going to always be a struggle to keep up with it. If you think back to 1976, how much, was this even thought of at that time? Was this even thought of at that time, in 1976? But now you look today, we have more information available to people for free online than ever before in history. And that will continue to get better and better as we go. But the legislature is struggling with how do they meet the test of the law and still maintain a rational point going forward. My advice is emails with select board members, town managers, whatever, public records. Those are public records.
I'm not worried. I assume they're public records, but what about open meeting? If I send an email to two other select board members saying, I really think we should turn down this person's request.
Now you're getting into the very gist of it.
And remember that a meeting is a gathering. So I don't know, it may be a stretch to, but if you're online in a chat room, maybe you are gathered. If you're trading emails around,
Looks like a meeting to me.
I
you're
think
right, I
that we struggled with that a lot, and we came up with what we thought was a really great solution, because everybody didn't like it, but everybody agreed that it was okay, including the ACLU and the VLCT. We figured if we satisfied kind of both of them, that we probably had.
And they rode down here together.
But the bottom line was, if you're in doubt, don't do it. If you have any question at all about whether you should be doing this, you better not, regardless of what the law says.
That was the law.
No.
Did you want a copy of what you did?
What did we do?
I think the other piece of this
It is
is
pretty good.
we don't know how the courts are going to respond to these issues if these come up, and I don't want to say we're waiting for the courts, but the courts haven't made any decisions on how the electronic media, and there's no record yet, so we're not sure how it's going to turn out, and the legislature is trying to do the best it can to meet the test. I mean, when you think about, I remember there was an issue around 1997 where there was a deadline of July 1st that an action had to be taken by July 1st. It had to do with a tax stabilization agreement, and 3 of us were out of town. We were on vacation. There's a 5-member city council. 3 of us were on vacation, so the city manager with our attorney. And I think it's Steve Stitzel. I think he's down here too. But with our attorney setting it up for us, we set up for a conference call. We warned a public meeting, an open meeting, and the agenda for the city manager's office. We had a conference, a speakerphone set up there. We put it out so that the public knew about it. The media knew that we were having this meeting, that 3 of us were going to be away. Two people would be in the office with the manager, and any member of the public is welcome to attend and participate in the meeting. We did actually have one person who came, a member of the public who came to the meeting. But 3 of us were, I was in Maine, somebody else was in New Jersey, and someone was somewhere else.
No, I could see that you could legitimately have an electronic meeting where the public was able to be there, in a sense. I mean, you could even have I don't want to get into the Facebook thing, but you could conceivably project something in a screen in a room, and everybody who comes to the meeting is there.
It's part
But
of
I'm
it.
more concerned with the other thing,
Yeah.
which is select board members do talk to each other via email, and it can become a trail, and it can become a discussion.
Do you want to hear what we put in the law?
Sure.
And this is the law now.
Okay.
We expanded the.
No, that's
the Senate. It's not yet.
That's the
Oh, no,
Senate
no.
version.
This should be the law. Because we did a really good job. And I'll take on any House member that says we didn't. But we expanded the definition of meeting. So it now says meeting means a gathering or a quorum for the purpose of doing business. Meeting shall not mean written correspondence or an electronic communication, including email, telephone, or teleconferencing between members of a public body for the purpose of scheduling a meeting, organizing an agenda, or distributing materials to discuss at a meeting.
But those
Those
three
are
the 3.
You start talking about it back and forth, you are out of line.
Okay, good.
Yeah.
Good.
And I think
hope you get it through that.
Yeah, we did.
we're supposed to get done by 8 o'clock. We're a little bit early.
Thank you very much. This has been very helpful.
Thank you.
But if
We
you have
hope that it is.
suggestions, if you have suggestions for how to deal with this issue of different silos in the towns and municipalities, and who's the keeper of the records and who's the boss of telling the other people about, get to Steve, because if we clearly can't hear from everybody, but we're relying on Steve to come with some suggestions for us on how to deal with that.
Isn't the